Okay, so hello everybody. Hopefully everyone can hear me. Brian, I can see you. Would you mind just putting a thumbs up if you can hear me? Excellent, thank you. All right. Oh, I think that might be me pinging. I should close that now. Okay, well, welcome everybody. It's 1 minute past 1 on 17th of May. I'm pleased to welcome you all to this event by the CIPD Essex Ipswich Branch, discussing HR issues and the return to the workplace. For those of you who do not know me, I am the co-chair of the Essex and Ipswich Branch, along with Brian, who we can see on the screen there. So welcome to you all. I'm very pleased today to be passing the reins across for this presentation to my colleagues at Birkett Long. So today we have Rianna Billington, who is a trainee solicitor in the team.
Hello.
And also Helena, Oxley, who is a solicitor in the team. And the reason being that I had my vaccine yesterday, so we needed to have a contingency plan just in case I had an adverse reaction. I'm pleased to say that I'm still okay. But rather than mess things around and sort of pass the reins here, there and everywhere, I've delegated. So I am going to just run through, if I can have the next slide up. I'm in the unusual position of not having control of things. So that's the agenda for today. That's what Rianna and Helena are going to be running through. We'll be looking at testing and vaccinations, flexible working, health and safety, and some other bits and pieces around changing terms and conditions and redundancy. We have put you all on mute. But if there are some questions towards the end, then we might invite you to come and join us and ask your question. Otherwise, if you do have any questions or comments, please do use the chat box. Hopefully you'll have a chat box there and you can type away and submit your questions or comments and thoughts. And we will come back to those at the end. Once I've passed across, I'm going to upload into the chat box the link for the notes and the slides where you can download those from the website. So please do get access to those and you'll be able to jot things in there, hopefully, as we go. So that is all from me. I will pass across to Rianna and Helena to take you through the rest of the presentation.
Lovely, thank you, Julie. So I'm going to begin by discussing two topical issues, those being testing and vaccines and the relationship with employees and the workplace. So going to turn my attention firstly to the topic of testing and the fundamental question, should employers be requiring employees to undergo testing when they return to the workplace? So at present, free asymptomatic testing is available under the government's workplace testing scheme. And since the 9th of April this year, individuals in England have been able to access twice weekly free rapid lateral flow testing. Now, whilst the government has acknowledged that it is a voluntary decision for employers to run testing programmes for staff, they are strongly encouraging them to sign up to regularly test employees to reduce the risk of transmission among those who cannot work from home. And the government are currently recommending that private sector employees offer their workforce who are on site 2 lateral flow tests every week. And they've proposed 3 options to help implement workplace testing. The first is an employer-led setup, so employers will set up their own on-site testing programmes. A second option is by using third-party providers. So you can engage a third-party provider to organise and run testing on the employer's behalf. And the third option is community testing through local authority testing sites. So an employer might ask an employee to go and attend these sites rather than run anything on site. So whilst that is all well and good, there are some legal issues that arise when considering implementing workplace testing. The first involves agreement and consent. So whilst the employer does have sort of understandable health reasons for wanting to test employees might have many arguments against this. The first being that they might say it's an unnecessary invasion of privacy. Also, in addition, the testing process can be quite uncomfortable. If any of you have had it, you'll know it involves a throat and nose swab, and it's not the nicest thing in the world. So employees might rightly argue that that's quite unnecessarily invasive when they're not exhibiting any symptoms and when there's other ways to ensure that infection is not being passed on to colleagues. So, for example, social distancing, which obviously isn't invasive at all. Now, an employer might be in a stronger position where the workplace is one in which it's difficult to maintain social distancing, but consideration needs to be given as to whether testing is a proportionate way to address that risk or whether there's other measures that could be put into place. And this needs to take into account any health and safety risk assessment that's been undertaken. Another issue with implementing a workplace testing policy is issues surrounding data protection and confidentiality. Now, the testing section of the ICO's guidance states that, and I'm quoting verbatim, as long as there is a good reason for doing so, employers should be able to carry out health testing on employees, and data protection law will not prevent them from taking the necessary steps to keep their employees and the public safe during the pandemic. However, obviously, if you are going to be using employees' personal data in this way, it needs to be done so with care, because maintaining and keeping testing records will amount to medical data, which is special category data. And in order to legally process this data, there needs to be a lawful basis under Article 6 and a separate condition for processing under Article 9. It's likely that employers will be able to rely on at least a legitimate interest and legal obligations under Article 6 and employment obligations and health obligations under Article 9. But regardless of the basis, the processing needs to be no more than is necessary. So the information that's being requested and recorded needs to only be for the employees that it's considered appropriate to request from. So to pull all that together, if the employer considers that it is entitled to process the data and there's a health and safety need to administer the tests and it's otherwise reasonable in the circumstances, then there needs to be consideration as to how best to implement the requirement. And one of those ways of implementation could be through a testing policy. And if you are considering bringing in a testing policy, I would point you to the guidance produced by ACAS, which says the starting point should be consulting with the workforce before putting any new policy in place. And this is important because the steps an employer takes before implementing any policy is relevant when determining the reasonableness of any dismissal that might result from a breach of that policy. So just to revisit the ACAS guidance, they emphasise that there's no legal requirement for staff to be tested, and that is the case, but they do recognise that some employers might want to introduce testing. And again, as I mentioned, the starting point, they say, should be to talk with staff or trade unions or employee representatives. And discussion should include things like how testing would be carried out and on who, and how staff would get their results, what the consequences of refusing to be tested will be, what the process to follow will be if someone tests positive, because the current guidance states that the worker and anyone they live with must self-isolate immediately and get a PCR test to confirm the result. A very important one, the level of pay if someone needs to self-isolate but cannot work from home, because understandably there might be concerns about employees getting tested. They might say, you know, I would be willing to get tested, but if I did test positive and I had to self-isolate and I can't work from home, what implications will that have for me and my pay? So being transparent about it in a policy may make your employees more willing to engage in the policy if they know what's going to happen and they're not going to suffer if they do have to self-isolate. In a similar vein, how their absence will be recorded if they do need to take time off work. And as already mentioned, how will testing data be used, stored and deleted in line with data protection legislation? So after any discussions that take place, a decision should be put in writing, and it should be in line with any existing disciplinary and grievance policies. And it should also be reviewed periodically as and when the position changes. And what should be kept in the forefront is this policy best achieving our aim? Is it proportionate in the circumstances? Are we justified in what we're asking our employees to do? So I'd say the overarching theme would be proceed with caution if you are thinking about implementing a policy, and do seek advice if you're unsure on issues such as data protection and consent. So moving on to vaccinations now, it must be said we're doing a really good job in the UK. Our vaccination policy is going very well, but as with testing, it can be a complicated area and it can be a controversial topic as it can divide opinion between people. So a key question that arises is it ethical and is it legal for employers to request staff to be vaccinated before they return to the workplace, given that some may refuse for religious or philosophical reasons? And there's also human rights arguments that come from that. Can you force someone to have a vaccine? And with that in mind, there has been an interesting ruling coming through from the European Court of Human Rights. The case name is on the slide. I won't try and pronounce it because I think I might butcher it, but it's a Czech Republic case. And in that case, it's been confirmed that a compulsory child vaccination programme with penalties for non-compliance is not a violation of human rights. So just to give a bit of background, this case concerned the Czech Republic's statutory requirement for children to be vaccinated against 9 diseases, and 6 applicants complained to the court about having been penalised for non-compliance. And what the court found was that the compulsory vaccination policy did interfere with the claimant's rights under Article 8, but this interference was justified because the policy had the legitimate aim of protecting against serious diseases. And the argument was put forward that vaccination protects not only those being vaccinated, but also those who can't be vaccinated for health reasons and are reliant on herd immunity. Additionally, the policy was found to be proportionate and the fines for non-compliance were not excessive. Now, this is an interesting ruling because there's been a lot of discussion about human rights concerns and compulsory vaccination programmes, but this case seems to suggest that human rights issues might not be a bar to such policies. But saying that, I would take this with a pinch of salt because this outcome was quite fact-specific, given that it concerned childhood vaccination against long-standing diseases with well-known vaccines. And that's one of the arguments for the COVID vaccine. It's not been around as long as some vaccines have. So a different outcome might be possible on different facts. But pulling all that together, we wouldn't recommend implementing a mandatory policy because of the sort of issues I've raised and some more issues which I'll run through now. One issue is that the vaccine won't be suitable for everyone. So if you're imposing a blanket policy, you're going to be singling out certain people who can't have the vaccine for health reasons, and that's going to be an issue. Another issue could be that employees might bring claims if you do force them to have it and they don't want to. So if you're requiring an employee to be vaccinated without their consent as a condition to providing work, that could amount to a repudiatory breach of contract, entitling them to claim constructive dismissal. And also there's risks of potential unfair dismissal claims if an employee is dismissed for refusing to be vaccinated, and obviously they have the requisite service to bring that claim. The employer could argue that the employee has failed to follow reasonable management instructions, but we haven't seen any cases in the employment tribunal on this yet, as far as I'm aware. So we're unsure which way it will go. We think there will be cases detailing this kind of issue, but there hasn't been yet. No rulings have come out yet, so it's risky. Also, because of the way we're rolling out the vaccine programme in the UK, it's done by priority. So in only allowing vaccinated employees to return to the workplace could potentially lead to indirect or direct age discrimination claims brought by younger employees. And although both of these things can be justified, that's obviously going to take time, money and resources to defend any claims. So it's worth putting the steps to ensure claims aren't being brought initially. Another issue could be that it might be difficult to justify a mandatory vaccination requirement on health and safety grounds, given that the vaccine doesn't actually stop you spreading COVID. Obviously, it's very good at reducing severe symptoms, but it doesn't stop the spread, whereas things like social distancing can. So your employees might argue, why is this being made mandatory when it doesn't stop the spread? And similarly, an employee who is compelled to receive the vaccine and who then suffers an adverse reaction might attempt to bring personal injury proceedings against the employer. And given we don't know the full side effects of the vaccine yet, that's quite an alive open risk. And of course, there's data protection implications, as I've mentioned already. So if we're advising against a mandatory vaccination policy, a better approach could be to encourage staff to be vaccinated with a voluntary policy. So this should focus on informing staff of the available information on the potential advantages and disadvantages of vaccination to assist them in making an informed decision. And ACAS goes a bit further and says that employers could consider offering things like paid time off for vaccination appointments and paying staff the usual rate of pay if they're off sick with vaccine side effects instead of SSP, and not counting vaccine-related absences in absence records or towards any trigger system the organisation might have. Again, this is a bit like testing. If an employee is worried about testing and testing positive and missing work and potentially suffering due to that, again, employees might think, I would like to be vaccinated, but I'm not sure if I'm going to suffer any ill effects. And if I do, and I have to take time off work, you know, I'll be in a worse off position. So being transparent about what will happen if they do fall ill might make them more willing to comply with the policy. So that's given you something to think about there on testing and vaccinations. I'm just going to pass over to Helena now, and she will take you through some flexible working issues.
Thank you, Rianna. So yeah, the government advice about working from home remains in place, but this could end on the 21st of June 2021. This is going to be dependent on low infection rates. But no matter the eventual end date, it's clear that return to the workplace is likely to be very different from before for many businesses, although not all of them. So we would advise on planning for the return to the workplace and thinking about what that's going to look like for your business. And starting early allows time to manage concerns and shows proactivity to employees, which could help to reduce fears that might encourage them to seek opportunities elsewhere. So having a think about what the future looks like for your business, is it going to be that you're going to have workers in the workplace all of the time, perhaps remote working all of the time, or something in between? But whatever it is, it's going to be very business specific. And so the first step in this planning process is really to consider what are the business needs. After that, it's about kind of having open and honest communications with your employees to ascertain what their preferences are going to be. And communications for this could be in the form of questionnaires, one-to-one meetings, or perhaps focus groups. But really that's going to be, again, a personal business decision on what you think would work best for your workers and employees. Another thing that we would recommend is engaging with managers to ascertain strengths and weaknesses they've experienced with managing employees that are working from home. So then the strengths can be shared as kind of best practice, and then the weaknesses can be discussed, and perhaps, you know, as a group you can overcome those so that it's a better experience for everybody. So on the slide here, we note points to consider during the planning process. So this is a non-exhaustive list, but just a couple of things for you to think about. So firstly is how to avoid a divided workforce. There's been talk about fears of this two-tier society that could develop between those that work remotely and those that are working in the workplace. So having a think about how you can avoid that is something that we would recommend. Also thinking about a phased and gradual return. So most employees have experienced, well, the majority of employees that have experienced remote working has been exclusively remote working. Less people have experienced a hybrid model. So doing something that's phased and gradual is going to help people to get on board and be able to adjust to what's been their routine for a long time now. Another thing to consider is the fact that this is a work in progress. It's likely that new advantages and disadvantages are going to come out of the process as we go along, and you can fine-tune this along the way. And we would just recommend not being afraid to assess and adjust as you go along. The objective: focus on a pragmatic and transparent assessment of the advantages and disadvantages of different approaches, and also make sure that your plans minimise discrimination risks. So, for example, a complete removal of home working could affect more women than men, potentially leading to claims for sex discrimination. Generally, women have more childcare responsibilities. So minimising discriminatory risks is something to consider as you go along. Ongoing points of consideration as well. So perhaps giving managers support in setting up new working arrangements for their teams in coordination and communication, as they'll likely be managing some employees that are working from home and some employees that will be in the workplace. Something else is also evolving the support that's given to employees. So especially those engaged remotely, and making sure that they're fully equipped, and making sure to continue to offer career development and allocating opportunities fairly to try to avoid this two-tier society that people are seeming to be a bit concerned about at the moment. So once you've carried out your initial consultation and you have an understanding of 1, the business needs, 2, managers' thoughts, and 3, employees' preferences, this information can form the basis of any policy or guidance that you put in place, and we would recommend that you do put something in place. And whether you label that a policy or perhaps take away that trigger word and call it guidelines, the main point is that you want a document that clearly sets out what the company's expectations are for everybody in writing. And taking this approach shows a united front, and this will help with employee morale. So next, going to move on to reluctant workers, reluctant returners. So despite best efforts working with the employees, some employers may be met with employees that are reluctant to return to the workplace, whether that be full-time or at all. So what can an employer do if an employee's preferences of returning to the workplace or wanting their position to remain permanently do not align with that of the employer's needs? So your starting point is, what is the government guidance at the time, and what do the contractual arrangements allow for that are currently in place? And we'd recommend that you meet with any relevant employee and listen to their concerns and their reasons for their reluctance. Also, the business needs to explain to the employee what the business needs are and have a discussion of both perspectives. Hopefully, there's a possibility that you could reach agreement this way. Another thing for employers to be mindful of is any potential discriminatory risks here. And as I've said, hopefully you can reach agreement that way. If not, there's a possibility that the employee might be able to bring a flexible working request. So flexible working requests are definitely something that I think employers are a bit concerned about, kind of receiving a tidal wave of these as we move closer to June. But it's one of the reasons that we would recommend getting ahead and developing and announcing any flexible working policy that you might be thinking about now. What are an employee's rights to make flexible working requests? Well, an employee with at least 26 weeks continuous employment can make a flexible working request for any reason. A request that's made under the scheme must be made in writing, must be dated. It needs to say that it is an application under the statutory procedure. It needs to state the change requested and when the change is to start. Explain any effects the employee thinks the change would have and how it could be dealt with. It also needs to say if any previous request has been made and when, and if the request relates to something covered under the Equality Act 2010, then it needs to also detail that. So, for example, if the request is to make reasonable adjustments for disability. The employer has 3 months to consider this request, to also talk with the employee, provide their outcome, and this also includes time for any appeal. The employer needs to consider the fact the application needs to be dealt with in a reasonable manner, and there are some circumstances under which an employer can treat a request as withdrawn. Some things to think about are that the employee could bring a claim to an employment tribunal based on the fact that perhaps the employer dealt with the application unreasonably, didn't respond within the 3-month time limit, didn't put forward one of the 8 grounds for refusal, which I'll move on to in a second, and also didn't base their decision on correct facts. And I did mention the fact that there are circumstances an employer can treat a request as withdrawn if the employee can argue that they feel that the request was withdrawn when it shouldn't have been. That's also something that the employee could complain to the tribunal about. It should be noted that only one request can be made in any 12-month period. There is ACAS guidance on flexible working requests, and the Employment Tribunal, if they're considering a flexible working request, will consider that ACAS code, so it's something that's worth being familiar with. So moving on to my next slide, a refusal of flexible working. There are 8 reasons that an employer could refuse a flexible working request under the statutory scheme that are listed here on the slide. So burden of additional costs, detrimental effect on ability to meet customer demand, inability to reorganise work among existing staff, inability to recruit additional staff, detrimental impact on quality or performance, insufficiency of work during the periods the employee proposes to work, or if there's planned structural changes and the request just wouldn't fit with those plans. So a couple of final points to note when it comes to refusal of flexible working. So a request that is refused, an employee may be able to bring a claim for breaches of that statutory scheme, if there are any breaches, but perhaps if you followed the process fairly and under the scheme rules, then there shouldn't be any breach there for the employee to bring and claim. However, there are some wider implications that we'd recommend considering from the outset. So additional protections arise where employees are seeking flexibility for perhaps childcare, religious reasons, or if they're disabled or they wish to look after someone that is disabled and internally have protected characteristics and may have protections under the Equality Act 2010. Employees could argue that the business has handled the request unreasonably or refused unreasonably and breached the implied term of trust and confidence. And this could give rise to grievances and potential constructive unfair dismissal claims. And now passing back to Rianna to discuss health and safety in the workplace with you.
Thank you, Helena. So yeah, just as a continuation of that, really, if you are going to be requiring your employees to come back into the workplace, it's likely that some employers are understandably going to feel anxious about returning. So steps need to be put into place to make the workplace COVID secure, as obviously you have statutory duties as an employer to provide a safe place of work and general legal duties of care towards anyone who might be accessing or using the place of business. So to discharge these duties, employers need to be carrying out suitable and sufficient risk assessments to identify any risks. And also these risk assessments need to be looking at different groups of workers for whom there might be extra health and safety measures required, so vulnerable workers or pregnant women, etc. Once the risk assessment has been carried out, measures need to be implemented to minimise the risks that have been identified, and all reasonably practical steps should be taken to minimise those risks. But that's not the same as having to eliminate the risks altogether. So there is a distinction there to be aware of. And similarly, if your workforce are still working from home, you should still be carrying out risk assessments, or you should be asking staff to carry out self-risk assessments. And this needs to concentrate on any risks associated with working from home. And of course, that can be updated in due course to reflect any plans for reopening. It's not only employers that obviously have duties, employees also have independent statutory duties to take reasonable care for their own health and safety and that of other people, and to cooperate with employers to ensure that rules are complied with. So therefore, it's important that your employees know where to access your policies and that they understand them. And with employees re-entering the workplace, it's a good idea to take stock and almost provide a refresher. So remind employees where they can access these policies and direct them to any new policies that you might have implemented upon their return. Now, with all that in mind, compliance with duties regarding health and safety is so important because the pandemic has seen claims about health and safety issues increase. So be mindful that employees have the right not to be treated detrimentally where they raise health and safety concerns under Section 44 of the Employment Rights Act 1996. So, for example, where an employee raises concerns, refuses to come into work or leaves work due to concerns about health and safety, and they have a reasonable belief that they or others are at risk of serious or imminent danger, then they can't be treated detrimentally due to raising these concerns. And employees also have the right not to be dismissed under Section 100 of the same Act for raising similar issues. If the dismissal is found to be related to this, then it might be an automatically unfair dismissal. So it's important, obviously, to be mindful to these, to the rights that employees have under these sections. But I'm also mentioning this because a recent ruling in the High Court confirmed that actually in only giving this protection to employees under Section 44 of the Employment Rights Act was a failure to properly implement an EU directive. And therefore, from the 31st of May of this year, workers are also going to be protected from this detriment as new legislation is going to be coming into effect. So be mindful that this protection will be applicable to acts or failures to acts on or after the 31st of May 2021. So workers can bring claims from then, but this isn't going to extend to Section 100 of the Act. So it's not going to cover protection from dismissal. That's still going to only apply to employees. So the key takeaways from this is that you should be ensuring that health and safety policies and procedures are up to date and in line with government guidance as the workforce returns to the workplace or continues to work from home. And also be mindful that claims under Section 44 and Section 100 have increased during the pandemic. And now that workers will also be eligible to bring claims under Section 44 from the 31st of May, the risk is even greater. So ensure compliance and the issues are being dealt with appropriately to avoid any potential claims. Similarly, it's really important to touch upon employee wellbeing as employees are being brought back into the workplace or continuing to work from home, because it can't be understated that the COVID-19 pandemic has been an uncertain and pretty tough time for us all, and it's affected people in many ways, not just the risks to physical health, but also psychological health as well. And you need to be mindful of this because, you know, things like anxiety about fear of infection might be heightened by coming into the workplace. There's socialized isolation that they might have suffered from because of lockdown, and there's challenging domestic situations if they're caring for vulnerable relatives, financial worries if there's been a reduction in income, and sadly some employees will have experienced illness or bereavement. So it's really important to remember this as we move forward out of lockdown, particularly in light of employees' health and well-being. As well, some employees will be really looking forward to getting back into the workplace, some won't, which is understandable. So supporting everyone is essential. So the bottom line is that fostering employee wellbeing is good for people and it's good for the organisation, and promoting wellbeing can help prevent stress and create a positive working environment where both individuals and the organisation can flourish. Some other benefits of investing in employee wellbeing are that it can lead to increased resilience, which is really important given the pandemic, better employee engagement, reduce sickness absence, and improve performance and productivity. So that is all well and good, but wellbeing initiatives often fall short of their potential because they stand alone, isolated from the everyday business, and they're not communicated appropriately or effectively to employees. So to gain real benefit, employee wellbeing priorities need to be integrated throughout the organisation and embedded in its culture. So to that end, we'd recommend that employers ensure they have a holistic framework in place to support people's physical and mental health. and offers sources of help such as counselling, employee assistance programmes and occupational health services where possible. And also employees need to ensure that line managers in particular feel they have the ongoing guidance and support that they need to support their teams, so they can have sensitive conversations with individuals that are actually going to be beneficial, and then they will know when to signpost to expert help when needed. So I've touched upon mental health, and just to that end, I'm going to run through some potential indicators of mental health issues. But a little disclaimer, it's important not to assume, as not everyone will show obvious signs, and nor can these indicators solely be attributable to mental health issues. But some things to look out for in employees is if they appear tired, anxious or withdrawn, if there's an increase in sickness absence or being late to work, if there's changes in the standard of their work and their focus on tasks has changed. And similarly, if they're less interested in tasks that they previously enjoyed, could be an indicator. And finally, if there's changes in their usual behaviour or mood, or how they interact with their colleagues has changed. So some things to be mindful of there. It's obviously going to be harder to spot with employees that are working from home, so it is important to regularly check in on staff to see how they're doing, just so they can feel part of the team as well still, even whilst they're at home. And it can be a difficult subject to approach, so an environment needs to be created where the employee feels safe to discuss their concerns, and they should be reassured that anything they tell you is in confidence unless there's a good reason for you to share it. And if there is, you need to be clear about who the information is going to be shared with. So fundamentally, the sooner you can become aware that someone's experiencing an issue, the sooner you can provide help and support. And I put there on the slide, be proactive, don't let issues fester. And this has been important, obviously, forever, but even more so as the workplace is coming back, people are coming back into the workplace. Okay, just passing back to Helena now to discuss some more HR issues.
Thank you, Rianna. So having a look now at change the terms and conditions of employment. So if a business decides it does want to implement a change, how does it go about this? So if we go back to some basics of contract law first, what are the different types of terms of a contract that could be something an employee could find? So one is express, which is something that's explicitly agreed, whether that's verbally or in writing. Two is implied, and that might be through custom and practice. And three is something that's incorporated, and that might be by law or through a collective agreement. Another thing to consider is consideration. So for any contractual change to be enforceable, the employee must be given a benefit or consideration. Usually this will be continued employment, but it's just something for the employer to think about. So does the contract allow for the change? The terms of a contract might be broad enough that the proposed change is covered, so no additional change needs to be made. The term might expressly allow for the change, or the contract might include a general right for the employer to make changes. So if you consider that the contract does allow for it, we would still recommend being cautious and reading any right to make changes restrictively. So if there is a right and it's reasonable to make that change, then a contract can be varied by writing to the employee, but also remembering to comply with any other terms of the contract there. But we would recommend discussing this with the employee and hopefully encouraging agreement that can be confirmed in writing, and taking the approach of, discussing it before putting it in writing is something that is good employee relations and management, so something that we would recommend. So what about if there is no contractual right? The most preferable approach, of course, is to obtain express consent and then have that put in writing. If that's not something that looks viable, then you could terminate the existing employment contract and offer re-employment on new terms. Another alternative is to unilaterally impose the change. So having a look at dismissing and offering re-engagement on new terms first. If the employee is not willing to agree to the change, the employer's next best option is really to terminate could be seen to be to terminate the existing contract and offer employment on terms including the change. However, this is not without risk, because the employee could claim wrongful dismissal, which could be avoided by complying with any notice or payment in lieu of notice clauses in the contract, or the employee could bring a claim for unfair dismissal. An employer could minimise the risk there if they can confirm that they have a potentially fair reason for dismissal, which might usually be some other substantial reason, on the basis of a sound business reason, and the employer needs to make sure that they do act reasonably during that process. It should be remembered that an employee can still claim unfair dismissal even if they accept re-employment on the new terms, although this might not be financially viable for the employee in the first place. It's important for employers to note the reasons why the employee objects to the change, and that's really important because that could be something that you could discuss with them and something that could be addressed. The other option is the unilateral imposition, which relies on the employee continuing to work as evidence of acceptance of the change, but this is riskier and really is a last resort. As an employee could respond by continuing to work but working under protest whilst bringing a claim for a breach of contract or unlawful deduction from wages. The employee could resign and claim constructive unfair dismissal, or the employee could just refuse to work under the new terms, which leaves the employer perhaps to dismiss them. Another thing to consider here is collective consultation. So if 20 or more employees are involved in any change, the Secretary of State needs to be notified, and the collective consultation obligations must be complied with. Non-compliance could result in the employer being ordered to pay a protective award of up to 90 days actual pay to each affected employee, and failure to notify the Secretary of State is a criminal offence. So you may have seen a recent decision, which was Tesco v USDAW in the Court of Session in Scotland. Tesco planned to fire and rehire staff on less beneficial financial terms, said to potentially cost some workers a third of their wages. The workers' union, USDAW, successfully challenged this in the Court of Session in Scotland, and the court made an interim decision legally prohibiting Tesco's from unilaterally withdrawing entitlement to retained pay and or terminating the contract in order to re-engage workers on new terms. So the impact of this case may be to cast doubt over the practice of fire and rehire tactics, although this case is not binding on English courts. Some latest updates on the case, however, USDAW have actually now issued High Court proceedings against Tesco for this fire and rehire tactic, and Tesco have said that they oppose the decision and they are seeking to challenge this. So this is going to be an interesting and important one for us all to follow. So moving on now to talk about redundancy and procedures. So to date, we've been reluctant to recommend proceeding with long-term restructure or redundancy whilst the furlough scheme remains operational. This is because any employee with more than 2 years service could argue that their dismissal was unfair, although this doesn't mean that it would be successful, but it's just still a point that they could make. Also, it's preferable to keep individuals in employment where possible. There is a risk to the employer that an employment tribunal could consider a redundancy unfair where furlough, which is a perceived no or low cost to the employer, is an alternative. But with the restrictions being lifted, our sights on the new normal working way of life and the furlough scheme in place until the end of September with increasing costs to the employer, businesses may need to make some tough decisions. We appreciate not all businesses will be looking to restructure or downsize. However, if a reduction in staff is needed, then a fair and reasonable procedure should be followed. And what is fair and reasonable? Well, that's going to be judged on the circumstances of each case, but carrying out a fair and reasonable procedure minimises the risks of a successful claim for unfair dismissal. And I'm going to give you a whistle-stop tour of the procedure to be followed in those circumstances. So number one, is there a redundancy situation? So there is a redundancy situation in one of three circumstances. So one, a closure of the entire business. Two, a closure of the part of the business where an employee works. 3, reduce requirement for employees to carry out the work the employee is employed to do. So if you decide you have got a redundancy situation, you should move on to step 2, which is thinking about preparations for this. So how many redundancies are proposed? If there's likely to be, in a 90-day period, 20 or more redundancies at one establishment, the requirement to collectively consult applies, and the Secretary of State must be notified, as I previously mentioned. However, if there's less than 20 redundancies, a fair and reasonable procedure should still be followed. Then within preparation, having a think about pools and selection criteria, and if this is something you need to consider. So if the entire business is closing, the entire workforce is at risk, and there's unlikely to be a need to carry out any selection process. If the entire business is closing at one location, it's likely to be fair and reasonable to consider that the entire workforce at that location is at risk, and there's no need to carry out a selection process. However, it's sensible to consider and take into account if there's any locations that are close by, because they may need to be considered as part of that. So selection might actually become relevant. If work of a particular type has reduced, consider carefully locations, who carries out that role, who could carry out that role, and if there is more than one individual in that role. If not all of those individuals are at risk, then selection will be necessary. And where selection is necessary, you need to consider and identify a set of objective criteria. Another thing to consider is alternative employment. So consider and collate a list of vacancies, if there are any, across the business and any group businesses. Identify any employees who are pregnant or on maternity, adoption, or shared parental leave, as special rules will apply to them. Also consider alternative approaches. Perhaps you could put forward a voluntary redundancies, and there's potential alternatives to compulsory redundancy that could be explored, and you should document why these may or may not be appropriate in case you need to rely on them at a later date. So moving on to 3, collective consultation, 20 plus employees. So collective consultation applies if the dismissal of 20 or more employees is proposed at one establishment within a 90-day period. And as I've said previously, we have to notify the Secretary of State in those circumstances. And the notification must be in writing, so recommend HR1 form, and has to be given at least 30 or 45 days before the first dismissal. So it will be a 30-day period if the proposed dismissal is for between 20 and 99 employees, and 45 days if it's for 100 or more employees in that circumstance. The notification also needs to be provided to the employee representatives, and notice of dismissal must not be given until the Secretary of State has been notified, and it is a criminal offence, again, not to notify the Secretary of State in these circumstances. So a quick run through of the procedure. So information must be provided and consultation take place with appropriate representatives. So this may mean that an election needs to take place if you don't already have those representatives. And consultation needs to take place with a view to reaching agreement about ways of avoiding the dismissals, reducing the number of employees to be dismissed, and mitigating the consequences of those dismissals. And as I've said about the consultation period, the actual guidance is that it has to take place in good time. So again, it's the guides of the 30 days or the 45 days before the first dismissal, depending on the number of employees that you're looking to dismiss. Just wanted to mention special circumstances may apply, which negate the need to comply with the requirements of collective consultation. However, even if special circumstances do apply, any reasonable practical steps you can take should still be taken. Just having a think about the pandemic. So when in the early stages, it's likely that COVID-19 could constitute a special circumstance. However, that's much more unlikely now. And it's likely that employers will be expected to comply with the collective consultation requirements. So moving on to 4, group meetings. Meet with all the employees who might be made redundant, and during this meeting, you should explain to them the reasons for the potential redundancies, how many jobs are at risk, and make it clear that redundancies are a possibility at this stage. Ways of avoiding the redundancies are being explored, just explain that to them. Also explain the pools and the proposed selection criteria, the right to take time off to seek alternative employment, and the procedure that you're going to follow, including for collective consultation and arrangements for the election of appropriate representatives, if that's necessary at your business. You should also ask the employees for suggested ways of avoiding redundancies, because they might have thought something that maybe you hadn't at that stage, and it's always recommended to take notes at the end of a meeting. Moving on to 5, the first letter. Confirm the information given during the meeting in writing, and if appropriate, set out arrangements for the election of the appropriate representatives, and perhaps include a ballot form with that first letter, if that's something that you're going to be doing. 6, carrying out scoring. If necessary, score each potentially redundant employee using a selection criteria that you formulated. Ideally, 2 managers should carry out the scoring so that the scoring is as objective as possible, and document and keep the scoring for each and every employee for your records. 7, the second letter. Write to the employees provisionally selected for redundancy, inviting them to a meeting to discuss their provisional selection. They'll have the right to request to be accompanied, and this should be included in the letter, as well as, for example, the reasons for the redundancy situation and their provisional selection, and a copy of their individual scores should be included with that letter. Allow them a reasonable opportunity to consider the letter before the meeting, so just make sure to send it in good time, and to be reasonable about that time between them receiving the letter and them having that first meeting. So that first one. So 8, and the first individual meeting. So meet with each employee individually about their scores, the proposal to select them for redundancy and the terms of the redundancy. Listen to and consider any comments from the employee and discuss any alternative roles that are available, or if there aren't any, just explain that that's the case. Remember to take a detailed note here. So moving on to 9, which is follow up. After the meeting, consider and follow up any suggestions made to avoid the redundancies and any comments made about the individual scores. An employee score could change as a result of the consultation process, and this must be compared to the other scores, and provisionally selected people might need to be reassessed. If there is a change, relevant parts of the procedure will need to be re-undertaken with those employees now in scope. 10, the second individual meeting. So if a decision has been made to make an employee redundant, and it's possible, you should invite them to a further meeting to notify them of that position, and they again can be accompanied to the meeting if they wish to be. Advise the employee that the decision has been made to proceed with their provisional selection, and go through the redundancy package, including their notice, holiday pay, and any statutory redundancy pay that they should receive. Remind the employee that they have the right to take time off to seek alternative employment, and again, take a detailed note of the meeting. So 11, the dismissal letter. Confirm the decision to dismiss them as redundant in writing, along with the termination date, any payments they'll be receiving, and you should also include a breakdown of any redundancy payment that's going to be made to them. Confirm the employee's right of appeal, how to appeal and by what date they need to appeal if that's something that they are considering. And 12, the appeal. So if the employee does appeal, an appeal meeting should be set up, and this should ideally be held by someone who's not previously been involved and who is more senior to the person who made the decision to dismiss initially. Following the meeting, write to the employee to confirm the outcome of the appeal and that is the final decision. So that was a quick summary of a fair and reasonable process. I think the takeaways from that are that you need to follow a process, it needs to be fair and it needs to be reasonable, and also take notes after meetings, take notes about a decision process and why you came to the decisions that you did. You just need to document that process from start to finish. And just a couple of points to mention before I pass back. Employees with less than 2 years service, not generally protected against unfair dismissal, and are unlikely to be able to successfully challenge any lack of procedure. Claims for discrimination can be made regardless of length of service. That's just something to take into account. Any contractual redundancy policy should be followed, and any non-contractual redundancy policy should be considered. Any variation from this needs to be documented. And I shall pass you back to Rianna to discuss furlough.
Thank you. So yes, just some final updates as we close out and before we move on to some questions. Just a quick update on furlough. Not going to go into too much detail as I think we're all furloughed out, but some changes to be aware of that are upcoming. As most of you will be aware, the furlough scheme is going to remain in place until the 30th of September this year. There's a question mark on the slide because we have a feeling that there might be a further extension or something will be put in its place. Nothing has been confirmed yet, but watch this space and we will update accordingly if anything does take its place, of course. Just obviously a quick background, but I'm sure most of you are aware. Currently, under the furlough scheme, the UK government pays 80% of employees' usual wages for the hours not worked, up to a cap of £2,500 per month. And the employer must pay employee national insurance contribution and pension contributions. Changes to be aware of, however, are that from the 1st of July of this year, employers must contribute 10% towards a furloughed employee's wages, plus employer national insurance contributions and pension contributions. And then from the 1st of August of this year, employers must be contributing 20% towards a furloughed employee's wages, plus employer national insurance contributions and pension contributions. Also, just a reminder that employees can take holiday whilst on furlough, including whilst on flexible furlough, but they shouldn't be placed on furlough for the purposes of taking holiday or to coincide with taking holiday. And any time off for holiday should be topped up to 100%. And also be mindful that since the 1st of December last year, furlough may not be claimed for any day that an employee is under contractual or statutory notice, and it doesn't matter whether the notice was given by the employer, the employee, or for retirement. So that is furlough in a nutshell, just with the changes to be aware of. Second thing to detail is the right to work checks. So as expected, the government has announced that the adjusted right to work check process will remain in place until the 20th of June of this year. Previously, these were going to end yesterday, and I would have been telling you today to be aware that the original procedure had to be taken place. But there had been concern over how employers were going to carry out face-to-face checks going forward, given that much of the workforce still remains working from home. And the guidance is still to work from home. And obviously interviews were being held virtually to maintain social distance. So the amended checks enable an employer to carry out checks over video calls, and applicants can send scanned copies of identity documents. Just to reiterate as well, the government has said that there will be no need to carry out retrospective checks, even though there has been an extension. So you won't, once the adjusted right to work checks end, you won't need to go back and request original documents. You will be covered, but unless extended again, do be mindful that from the 21st of June, the original procedure will need to be carried out. So that's checking original ID documents and carrying out face-to-face checks. But again, do watch this space, because the groups that lobbied for the extension are also lobbying for virtual checks to become commonplace on the basis that they've worked well during the pandemic, so why can't we continue using them? But there's nothing been confirmed yet. And lastly, just on the subject of DBS checks, because we had a few queries about these on a previous webinar, there are also temporary measures in place to allow employers to check ID documents over video link and use scanned documents in urgent cases. They haven't specified what urgent cases, what constitutes an urgent case, and they said that in all other cases, normal identity checks should be used. So if you have been using temporary arrangements, so you've been doing video link ID checks and scanned documents, be mindful that when the individual first attends the workplace, original documents need to be looked over. So best practice would be to carry out the normal identification checks. If you have to carry out temporary checks, then you can do so, but you will need to re-verify when the individual attends the workplace. And there's no confirmed date for when these arrangements will need to stop at present. So the government hasn't given a date like they have for the right to work checks. I assume it will probably be around the 21st of June when the lockdown restrictions end, but we'll update in due course when we hear more. So that was everything. Just sort of wanted to touch upon miscellaneous. I think I'm just going to pass back to Julie now, who's just going to talk through some upcoming CIPD events, and then we can take some questions.
Just to prove I was listening, I put my video on at the right time. Okay, so just with my co-chair CIPD hat on, I have been I've been spamming everyone during the presentation. There's a benefit to having me presenting rather than sitting in the background. Hopefully you'll have found the link to the notes, so please do follow that. But also I've popped into the chat a link to some upcoming events. So we've got two which are live currently. We have our annual meeting, which is tagged with an event presented by one of our branch committee on how to become a strategic thinker, and launched yesterday. I suspect some of you might feel this is quite topical. We have put in an event on preventing burnout, specifically with a view to looking at HR. So if you follow the link to our future events, or if you just Google CIPD Essex and Ipswich Eventbrite, you will come up with our current live events there. Also, just to let you know that there are some upcoming events from CIPD Central. So we have, thank you, the Festival of Work, which is next month, and also the annual conference and exhibition in November. The Festival of Work, I believe, is online, and the annual conference, I believe, is planned to be an actual face-to-face going out event, but I guess we will have to wait and see what happens there. Also, just a word for those who are CIPD members, there are a good number of benefits for CIPD members. So if you just Google again CIPD benefits, then you'll be able to get to those as well. Finally, if we can just move on the slides. So again, I've popped in the chat over the course of the presentation a couple of links to surveys, one for today. So please do give us your feedback, positive, negative, and everything else in between, because we do look at that and we'd love to know what you think. And also for future events, for obvious reasons, the branch are carefully considering how we do and deliver future events in the future. So please do fill that in. Neither of those surveys will take you a huge amount of time, literally minutes. There's, I think, 4 or 5 questions for each of them. And again, we are looking at those results, and we will be hopefully tailoring our events around that. Needless to say, with the caveat that we can't please everybody, but we'll all do our best to please as many as we can. So that takes us on to questions, I think. So Anna has asked, and I'll let you fight between you who does this. What happens after the 21st of June, or whenever, depending on when we go into phase 4, I think it is, if we are still working from home? How are we meant to be able to check right to work documents? There's too many abbreviations. I know that even before COVID, some businesses work from home. So how did they do this? Any takers?
I believe one way they could do it is also checking an applicant's share code. So if an applicant has provided you with a share code, you are able to do the checks online, and you can check the right to work status online. But that is that's why the groups are lobbying to obviously make virtual checks commonplace, because the issue is that if we don't sort of come out of lockdown, how are employers going to carry out the checks? So that's partly the reason why the lobbying is taken place. But as I said, you can check an applicant's right to work if you have been provided with a share code. But otherwise, I think, unfortunately, the advice will just be to try and carry out the checks as best as possible until the position changes. But it might change, so we will see a bit nearer the time.
Yeah, I mean, I think my money is on the adjusted process being extended, if I'm honest. Obviously there is the Indian variant excuse me, that the government are sort of looking at in terms of where things land, and I think there are going to be businesses who will remain in a hybrid situation or a work from home situation beyond the 21st of June or whenever that might be. But I mean, we will be as a branch, no doubt will be, if things are changing rapidly or deteriorating or whatever, then we'll I'm sure be putting on an event. And Birkett Long do publish newsletters, and we tweet and link in and etc. So please do follow us or get in touch with one of us, and you can pop yourself onto our newsletter. And actually the survey does allow you to give your details to Birkett Long, and we can pass those across and add you to the newsletter, because whilst I do have access to all of that information, I can hand on heart say that none of that makes its way to Birkett Long unless you expressly give us your permission, because we are fully GDPR compliant, of course. So you'll need to give us your consent to pass that information along. Okay, so Catherine has asked a question, which is, we have a complete range of requirements from our employees, ranging from those who wish to return full-time to those who wish to remain full-time at home. Manufacturing business, there is a real us and them between those who have continued to work on site and those working from home, and believe that having everyone back for some of the week, 2 days a week, is desirable for employee relations, even though most of our employees work from home. For most of our employees, work from home has worked reasonably well. Is this sufficient reason to reject flexible working requests from those who apply to work full-time from home? Who wants to take that?
I'm happy to take that one. So I think that's, I think that's expressed the point and the real risk of this two-tier system or society that's going to be created, Catherine. So thanks for your question. I think, unfortunately, so I've listed the 8 reasons under the scheme that a business can validly reject a request for a flexible working. I think that's a valid business reason in itself, but under the scheme, that I don't think that comes under it really. So there was the additional cost, effect on ability to meet customer demand, reorganising work amongst existing staff, inability to recruit additional staff, detrimental impact on quality and performance, insufficiency of work during the time that the employee wants to work, and planned structural changes. Even though that makes complete sense, I don't think it would be covered under one of those, unless one of my colleagues wants to disagree, which is totally acceptable, but...
Let me just have a look. I mean, I suppose it could come under detrimental impact on performance. Ultimately, there has to be a business first approach to it, subject to discriminatory aspects, and it's, I mean, it is, I hate to say it, but it is going to depend on the circumstances and the individuals and the roles and the extent to which the team dynamic is being adversely impacted. I'm afraid that there's no kind of golden, I'd love to be able to say, here you go, this is the golden answer for people, but unfortunately this is going to be, I mean, it is going to be a common issue, sadly, and you know, there are inevitably going to be individuals who are perfectly happy at home and don't want to be coming into the workplace, and others who have been there throughout, and some who have had that kind of hybrid approach and you know, sort of evolving as lockdowns eased and then we've gone back into it and so on and so forth. But I mean, I think I would say it certainly would be possible to pop it under the detrimental impact on performance and possibly quality, actually, because the refusals, the grounds of refusals are quite broad. So yeah, that would be my take.
Just to add to that as well, I think it's depends on what stage you're at with it, but that's again, you know, during the meeting that you might have with the employee to discuss it, it's stating the business reasons. So like you suggested, you know, we don't want to have a divide in our workforce, and really having employees in a couple of days a week, or just working with them to say, okay, this isn't what you want, but what is there that we could suggest, or what is there that you would suggest that would work, so that we could all be, you know, walk out of here happy, kind of thing. So even ahead of people making flexible working requests, like we suggested, if you have those conversations, hopefully they won't make them, but if they do, that's still something you can discuss. And I guess if you can make an arrangement that works for both of you before you even have to pick one of these 8 reasons to reject it, it's just safer again from them bringing any potential claims against you.
Yeah, I mean, as you say, Helena, it's having that open, honest conversation, isn't it? Discussing what their reasons are and explaining actually that, you know, it's not a one-sided conversation. There is a business, there is a, you know, there's a team ethos that needs to work as well. So Rianna, this one's for you. Could you please just confirm that those I keep thinking it's return to work checks which have been done virtually during COVID don't need to be done again face-to-face with original documents?
Yes, the right to work checks you don't need to do any retrospective checks. I might have confused you there by skipping to DBS, but definitely no retrospective checks needed for right to work checks.
Yeah, absolutely. Okay, so Liz, can we ask staff to volunteer information about if they have had the vaccine or not? This would give us visibility, at least, if there is good uptake. Now, I think our HR partner is still on the line. She's going to kill me for this, but I had my vaccine yesterday. So she needs to make a record of that and make sure that, well, she doesn't really, but who wants to take that?
I think you can, but you do have to be, there has to be a justifiable reason. So if you're explaining that, look, you know, we want to keep track of who's had the vaccine, to consider whether we need to put a policy in place, could be a good way of kind of approaching the subject. But again, it's making very clear how you're going to deal with that data, because it is going to be medical category data. So explaining that it's going to, you know, if you do keep it, you need it for this reason, there's a legitimate aim that you're trying to achieve, and make it really clear that you're only going to hang on to it as long as you need it for, and that they don't have to provide it, you know, if they don't want to. Start there. And just make sure that you just have to show that you're doing it for a legitimate reason. And as I sort of mentioned, you know, we think you'll be able to process the data under legitimate interests and legal obligations and employment obligations and public health obligations. So there are, you know, there is the ability to do it, but you just have to make sure that you're emphasising you're going to take care if you are going to process that data.
Yeah, I mean, I would just add to that, there's a distinction to be drawn between recording it against an individual's name, which would be personal data under the Data Protection Act, and anonymous data, where in effect you're keeping a tally of who's had it and who's not, just from a numbers perspective. If it's from a numbers perspective, then I think you have less to worry about from the perspective of the GDPR, because it's anonymous. But it, as I say, if it is against individuals and you're looking at it from the perspective of they have contact with the public, or you're sending them out to third parties, etc., then, as Rianna says, the chances are you'll have a legitimate reason to process that information and record it against the individual. So hopefully, Liz, that answers your question. So Anna has a follow-up. Is there a maximum time period after start date that we need to check them physically? So this is the right to work documents. I'll take that one if I may. The right to work checks have to be done before they start work. So if we move into the old regime after the adjusted regime, technically speaking, you need to do the checks before they start. Now, if they start at 9 o'clock in the morning, there's no reason why I can't do the checks at 8:55, but it has to be before, I'm afraid, which I know does present a problem, or potentially. So, Catherine, if an employee wishes to move to a hybrid form of working after COVID, half in the office, half at home, does this have to be requested via a flexible working request, or can this be done on an informal basis?
I'll take this one. I don't know if I could say my personal recommendation on this is it's probably better to do it on this informal basis. So informal in the sense of you have those conversations with the employees, what are the business needs, kind of getting all of that information together and putting it in a policy or guidelines. That doesn't have to be done through a flexible working request, because that would then be, you know, each individual employee putting forward a flexible working request, and one, administratively, that's going to be a massive headache, and also that is more formal and definite. And I think what I've been trying to get across is the fact that this is going to be an ongoing working project for all of us. You know, we're as you can see, we're all working from home, so it's something that a lot of people are going to be going through, and it can be fine-tuned along the way. So suggest for now, you know, putting something in place, putting a policy or guidelines in place, seeing how it goes, fine-tuning it along the way, and then it's kind of flexible working requests might be for people that aren't happy with that, and maybe so a few people on the side might need something different. But yeah, you don't have to do it via flexible working requests. No, you can take the form of making it a group thing and having a policy or guidelines which could be considered to be more informal. Yes.
Yeah, I mean, I would just add to that there is, I hesitate to say this, but I will say it, there is an advantage to requiring the request to be made through a statutory flexible working request, because it gives the protection of them not being able to do it again within a period of 12 months. But equally, the statutory regime is very regimented, far less than it was when it first came in. But there's a certain time period within which you've got to consider the request. And I think actually, you know, the last thing you need is more red tape as an employer at the moment. And I think it's a case of if you can reach these agreements in advance of having formal flexible working requests, etc., then I would say there's certainly advantage to doing that. Equally, there are advantages to the flexible, you know, requiring individuals to go through that process. As I say, gives you the protection, you can have sensible conversations and so on and so forth. Okay, so I think last question from Kate, unless anyone wants to add any in later as we go through. So a lot of employees have changed their childcaring arrangements over the past year, fitting school runs into their working day rather than having after school care. How would this impact a flexible working request based on caring responsibility? Could an organisation insist on alternative childcare being arranged to allow a regular return to the office? And just before I pass that over to anybody, if I have missed anyone's questions, please do just drop them in. And otherwise, I think this might be the last one. So who's taking flexible working for childcare? Helena.
I think before we even have a look at our 8 reasons to refuse, the first thing is that detrimentally affecting the business at all? Because I understand it's a change to what's usually done in, you know, pre-COVID times. But, you know, I guess you're asking, so potentially it is, but, you know, is it really affecting the business so that you actually do need it to revert back to what it was before? In short, I guess the answer, if the answer is yes, we have a look at these 8 reasons for refusal if that individual decides they are making a flexible working request. And I think we might need, this might again be kind of case specific, because it could fit under one of these examples. So I'm just looking at them at the moment.
Sorry, Helen, I'm just going to jump in. I suspect, and Kate can correct me if I'm wrong, it might be a case of, in order to do the drop-off and collection, depending which end of the day, it could be both, that there might need to be an adjustment to working hours on the basis that they're starting later and finishing earlier in order to get to.
Okay. Just reading the end of the question then. So could an organisation insist on alternative childcare being arranged to allow a regular return to the office? So I'm not, although wanting to
be both, isn't it? Return to the office and hours, maybe. Yes, Kate's saying also wanting to be full-time from home.
I think this is a perfect examples of why this is going to be tricky for everybody moving forward. I'm looking at these 8, and maybe I'm just not as familiar as you are, Julie, but is there something that jumps out, or again, is it going to be?
Well, I suppose, I mean, I've jokingly said, since the flexible working, right to request flexible working came in, that if you can't find a reason to refuse, then we're probably not thinking hard enough. But I think the critical issue is going to be around the potential discrimination. Yeah, and again, as a gross generalisation, females continue to have the larger responsibility for childcare, and if the individual is saying, I want to work full-time from home in order to facilitate childcare, and or I want to work reduced hours in order to facilitate childcare, then you do need to be mindful of the risk of an indirect sex discrimination claim, and you would then need objective justification around why individuals need to be in the workplace, and or why they need to work the hours that you are wanting them to work, so that you can't accommodate their you know, dropping child off and picking up. I must admit, I mean, I've quite enjoyed the few times I've waltzed my children down to school in the mornings, and they do enjoy me collecting them in the afternoons on the very few occasions I've done that. But that doesn't necessarily mean it's right for the business. And as you say, I think there are going to be some difficult discussions to be had, and difficult decisions in the future. But I think, you know, you've got ultimately you need to look at what is the reason why you cannot accommodate what they're requesting, and I suspect you will be able to get that reason into one of those 8 reasons. But I think the more fundamental question is going to be, can you defend an indirect sex discrimination claim? Okay, yes, Kate, I think it is going to be a debate that crops up and will continue to crop up, and I really do wish I could give you a sort of magic solution, but I'm afraid I can't. What I can say is that if you have any of these issues and you want to talk to any of us, then by all means do get in touch. So Liz, if a business has allowed this previously, it may be difficult to go back to the previous ways of working. Absolutely. I mean, I think when, well, throughout the lockdown, I've certainly sort of, you know, the real issue is, of course, if working from home has worked for particular roles, particular individuals, it is going to be difficult to say, not to say impossible, but difficult to say that individuals now have to revert to going back into the workplace. Equally, you know, we've had a number of discussions, I think, haven't we, Helena and Rianna, within the team and as part of our as part of our forums around whether or not the flexibility in lockdown is going to tie a business to a particular approach. And I personally don't think it will. I think a tribunal will look at how it's worked, but I don't think a tribunal will say, well, it's worked through lockdowns, therefore you have to continue it in the future, because lockdown has been in effect imposed. People have been required to work from home where they have been able, and you have risked a criminal prosecution if you've left the house in circumstances where that wasn't the case. That is not going to be the case. Well, it isn't the case now, and isn't going to be the case in the future, subject to further lockdowns. So I think, what was originally started off as a relatively short-term arrangement, and obviously has elongated, I don't think is going to stymie everybody. But I think it is going. The realistic issue is going to be, well, people will say it's worked. It has worked, so why should I? And that's why you're going to have to be very clear about one of these reasons, and also alive to the potential of indirect claims, and or indeed other types of claims, not just limited to childcare, but disability and so on and so forth. So anything either of you want to add, Rianna or Helena?
I think I'd just add to that, when having a look then at flexible working requests, like on the back of what you said, the step before looking at can we reject it under one of these 8 reasons, the step before that is there any discriminatory risks here, and tackle that, because even if you can fit it into one of the 8 refusals, as Julie said, that if there's a discriminatory risk, you're probably wasting time having a look there. So I think, I just wanted to add that perhaps change the order in which you handle that process.
Okay, so I've just reposted the links in there, so you've got the links to the notes and the slides, links to our future events, and the 2 links to the surveys there as well. So I don't think I've missed anyone else's questions or comments. Obviously I'll just keep an eye on the chat, but to say thank you both very much to Rianna and Helena for what I think was a very good and interesting session, and obviously some good feedback coming in from everybody there. Thank you also to you all for joining us today. As I say, we will be sort of putting together events around any changes that there might be as and when we need to, if we need to indeed. So don't forget about the 2 future events, strategic thinking, including our annual branch meeting, which is going to be as short as we can make it, and also the prevention of burnout within HR. So hopefully we will see some of you there. So thank you very much to everyone, and as I say, thank you to Rianna and Helena as well.
Thanks everyone.
Thank you.